YouTube, it's Tone back with another one for you. This one is a pretty good one. I think you guys are gonna like it. It pertains to the commercial nature of the system that we operate in. I know it's been a while. It's been a crazy few months, crazy fucking few months, kind of like a movie to be honest with you. So, but I'm still having fun with it. I'm enjoying it. So, right here we got Title 15 and more. This PDF really goes into detail about some of the different aspects that you can utilize if you're having any issues in the commercial realm with people making claims against your estate and different ways that you can, different ways that you can maneuver in order to get out of there, using these codes and statutes. And Title 15 is huge. There's a lot of different clauses in the Title 15 that pertain to, a lot of these different entities that usually abuse people. And, if you don't know any of these laws to back you up, then you're gonna fall right into all the traps. Administrative law being a huge one. Yeah, you're gonna hit cars and shit going on behind me. I'm out in the middle of the city, so it is what it is. All right, so here we got Title 15 and more, 100 plus consumer laws, violations, full affidavit edition. So, hang on, let me write down this screenplay. So here we got Fair Debt Collection Practices Act, and this is under Title 15, Chapter 41, Clause 1692, Fair Debt Collection Practices Act. All right, so here we got the Fair Debt Collection Practices Act is very powerful as it intertwines with many other federal laws and provides the greatest protection against of all consumer laws. A strong understanding of the Fair Debt Collection Practices Act allows for the freedom of alleged obligations, unfair and abusive business practices, and most important, freedom from mental slavery. To enforce these laws. These are best quoted in an affidavit. This way, as the law states, an affidavit which quotes federal law can only be rebutted with federal law inside an affidavit in response, rebutting the original affidavit point for point. If the affidavit is not rebutted, then your experience put in an affidavit becomes truth. And so that's the way it works, right? So you have 30 days. I mean, you can give them 10 days. I mean, it's up to you at that point, if they're violating your rights. So any affidavit that goes unanswered is assumed to be truth in the court of law. And so that's why it's always best to answer back with an affidavit. Otherwise, you didn't answer back at all. And then they can go ahead and fucking steamroll you if they want to. So you want to master the affidavit in order to defend and assert yourself in this business world, often referred to as commerce. It's not often referred to as commerce, it's because it is commerce. Like that's just what it is. That's the nature of the game. And they like to have you believe that it's really something else, but it isn't. So Title 15, 1692, Congressional Findings and Declaration of Purpose. 15 U.S.C. Clause 1692A. 1692A, consumer has a right to privacy. Affidavit, notice it is a fact. The affiant is a consumer and has the right to privacy in accordance with 15 U.S.C. Clause 1692A. And so these are the laws that back up your right to privacy, which we all do have, right? So when they start making these claims and dragging you into the public venues in court, violating your right to privacy, putting on these public shows, that's a clear violation of your rights. So 15 U.S.C. Clause 1692A3, uh, consumer, natural person, alleged to owe, right? And so these are all verbiage that you can go ahead and place in your affidavit. And these are all backed up by actual laws that they can go ahead and look up. And, so these are the laws that actually regulate commerce. And when you understand that we're operating in maritime, then you understand that U.S.C. United States Code and the Uniform Commercial Code is really what's going to be governing all of these transactions. So affidavit, notice it is a fact. I, the consumer, is a consumer and a natural person in accordance with 15 U.S.C. 1692A3. And so a natural person would basically be like a estate or like a trust as well. So then 15 U.S.C. Code Clause 1692A2, communications via any medium, affidavit, notice it is a fact pursuant to 15 U.S.C. Clause 1692 A2, communication is conveying information through any medium, which includes mail, email, publications, text, letters, phone calls, etc., as it pertains, so be it. Right? So these are all ways that they're violating your right to privacy by, putting all your information out in these public venues like that. Right? And so if you already have a trademark against your name and things like that, we're going to get into different ways too as well that you can go ahead and invoice them for illegal use of your trademark and things like that. So because if people are trying to use your information for monetary gain without your permitting them to do so, then that's a violation of your trademark agreement, which should be in the form of a contract, and you should have given public notice, prior to, invoicing them and hitting them with like a countersuit or things along those lines as well. So 15 U.S.C. 1692A4. Creditor proves consumer as the original creditor as the consumer answers the question, who created the debt? Creditor means any person who offer or extends credit. Creating a debt or to whom a debt is owed also excludes alleged creditors because it does not include any person who receives an assignment. And so you would be assigning them the credit whenever you fill out the application. The application is you applying the credit into that situation. It's not you asking for it because they don't have credit to give you. All these corporations are bankrupt. They need your energy. So anytime you fill out an application, you're actually applying your credit to that business, and that's how that works. So then the application becomes the actual security, and then that gets monetized, and that's where the money comes from. So affidavit. Notice, it is a fact pursuant to 15 U.S.C. 1692A4. The term creditor means any person who extends credit creating the debt. I extend the credit which makes the original creditor in fact. And so that's how that works. And you'll notice too, whenever you get into any of these transactions, nothing's gonna go down until you sign something. So your signature is the actual value of the whole transaction. So you are the creditor in fact, and and they'd be hard pressed to prove otherwise. So 15 U.S.C. 1692A5, debt, obligation, or an alleged obligation, affidavit. Notice it is a fact pursuant to 15 U.S.C. Clause 1692A5. A debt is any obligation or alleged obligation. Hang on, let me try to zoom in on this because this writing is fucking tiny. 15 U.S.C. 1692A6, debt collector. To trap a debt collector and prove the company does in fact fall under the Fair Debt Collection Practices Act, go to your Secretary of State and perform a business name lookup. And if it is anything different than their contract or DBA, then they are a debt collector. You can also use this site, and this is a corporation's website, to find this information. Affidavit. Notice, it is a fact, affiant has reason to believe, and so does believe, the company name is a debt collector as described in 15 U.S.C. 1692A6, which includes any creditor who, in the process of collecting his own debts using any name other than his own, as shown in Exhibit A, would indicate that a third party is collecting or attempting to collect such debts by way of buying, selling, or moving of products, services, or money across state borders, or using interstate commerce, or the mails in any business, the principal purpose of which is the collection of any debt, or who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed or due to another. So those would be the definitions that would apply to companies attempting to collect the debt. So those are the definitions there. And so, simply if any of these entities are falling under these categories, then that's exactly what they are. And really, all of them are falling under this category because if you're operating in the public, you're operating under a fictitious entity that is a corporate entity more than likely. You have an EIN, you pay taxes, and so, and they are registered with the IRS. So, all of these actions are going to be debt collection actions. So 15 U.S.C. Code 1692A6, a debt collector is defined as anyone in the business of collecting a debt. Affidavit. Notice, it is a fact that I, agent for principal, all capital letter name, am aware that the company is a debt collector by the legal definition pursuant to U.S.C. 1692A6. A debt collector is any person who uses instrumentality of interstate commerce, such as the mails, in any business which the principal purpose is the collection of any debt, or who regularly collects or attempts to collect directly or indirectly debts owed or due to asserted to be owed to another person. And so even the word person, you want to look that up, U.S.C. 26 person, you look that up and and even U.S.C. Individual, right? So uh these are all going to be corporate entities. They don't exist as anything else. The live living world is not allowed to even uh communicate with the dead, which would be the corporate entities. So they can only make communication with other dead entities, and that's the whole reason of them creating the ens legis or the straw man, if you will. So then here we have 15 U.S.C. 1692A7. Location information includes telephone number, place of abode, place of employment. Affidavit. Notice it is a fact. Location information includes the affiant's telephone number, place of abode, or place of employment in accordance with 15 U.S.C. Right? And so those will all be registered with the Secretary of State in their state as well, I would imagine. Right? Because they do got to give notice, and that does, and so that all has to be filed with the Secretary of State. 15 U.S.C. 1692B. Uh, must identify themselves and, if requested, state their employer. So they would have to identify themselves as who it is that they actually are and who it is that they work for. Affidavit. Notice it is a fact when the affiant requests the information from the company as a debt collector, they must give meaningful disclosure and identify themselves and their employer as requested. The affiant did not receive any meaningful closure and has proof in the exhibit XYZ with the company name in violation of 15 U.S.C. 1692B1, right? And that can usually be done with a W-9. So you can go ahead and send them a W-9 and ask them to go ahead and fill that out so you can get their information. If not, you can usually find their information located on the Secretary of State website, or you can even look up their name on the IRS website to get their EIN and then just do it backwards from there. Backtrack it that way. So 15 U.S.C. 1692B2 states a consumer owes any debt if the debt has been reported. This is a violation of 1692B as someone is stating the consumer owes a debt within a publication. So this is when they start to public any supposed debts that you owe to the credit reporting agencies, and that's a violation of your right to privacy as well. All right, so affidavit. Notice it is a fact that I, the affiant, was told I owed an alleged debt proven by the exhibit. This is a violation of 15 U.S.C. 1692B2. Right, and so these are all the laws that you can use to go ahead and get your compensation for the violations. So 15 U.S.C. Code 1692B3 cannot communicate more than once unless requested to do so unless earlier response was erroneous or has reason to believe the location of information is correct or complete. This code is important for unwanted phone calls, which is also a violation of the Telephone Communications Protection Act. Affidavit. Notice it is a fact that affiant did not consent to communication with this company more than our initial point of contact. I did not contract with the company, nor did I request to have the company contact me back. I was contacted numerous times and had proof in Exhibit XYZ, the behavior by the company as a debt collector is a violation of 15 U.S.C. 1692 B2 and the TCPA 47 U.S.C. Code 227. All right. And so these are the games. So these are the games that are getting played there. And they get away with it more than not because not many people know about their rights, so they just keep on doing it, you know? But so these are the laws that you can use to go ahead and correct those erroneous communications. And you can just give them the benefit of the doubt and assume that they didn't know and then just move accordingly. So 15 U.S.C. 1692 B5, nothing on the envelope which indicates debt collection, which includes a symbol or logo. Affidavit notice, it is a fact the affiant is aware and has proof in exhibit XYZ company name has included in its symbol while attempting to collect the debt, which is violation of 15 U.S.C. 1692B, right? And so, if you already have a copyright associated with your name and all these things as well, then you can use those too. And those would be awesome tools that you can use to go ahead and to get yourself out of these fucking annoying situations because they'll just keep on. And keep in mind that every time they send you a new communication, that's a brand new offer. And so they'll always keep on trying to bring the debt back to life in different ways like that. So, you don't want to just take the communication, throw it into your drawer, and just assume that it's going to go away because by you doing that, basically assumes, I mean, they can legally assume that you actually accepted their offer and move forward with collecting on it. So you always want to respond and make sure that you respond in the form of an affidavit, and it does have to go to a binding agent of that corporation, be it the president, CEO, etc., not just to the corporation in general, because you have to have somebody to hold liable. All right, so it does need to go to a binding agent, and definitely look up the administrative practices, so you can get the administrative process done correctly, because that's going to be a huge part of your winning court. Because every time we have these communications via certified mail in the form of affidavits with notaries and all these things, we're actually holding court. So you don't even have to have a court process if you know how to do the administrative process correctly. You're actually holding court through the mail. All right, and so that's how we handle that. So, uh, so if you need this PDF, let me know. This shit is fire. And so this will fall under the Fair Use Act as well, because this dude does have a this dude does have a copyright notice and all that shit. He says nobody can. So whatever. Either way, we got it done. And so, you know, it is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.